This is a panel on jurisdictional overlap, and it's the balkanization problem that that Senator King referred to, and a couple of others have referred to, and it's not normally the topic of debate when people talk about regulatory approvals. They talk about the environmental review process. They don't normally debate what might be called a problem of federalism, of overlapping agencies. As I suggested, other countries have addressed this problem. America has not, and one of our goals today is to try to bring this into this aspect of delay of infrastructure into the public discussion. We have a panel that has both some former top federal officials as well as people who actually work for companies that are doing infrastructure, who will explain how these constraints work. I think this is approximately the order of presentation. Don Elliott is as he said, is a Yale Law School professor and also a colleague of mine at Covington and Burling. Steve Black is a lawyer at Bingham McCutcheon in San Francisco, but until recently he was counselor to the Interior Secretary Ken Salazar and is very involved in trying to build projects and deal with state and local constraints. Lynn Scarlett was the Deputy Secretary at the Department of Interior and is now newly at the senior policy position at the Nature Conservancy. Is that right, Lynn? Yep. Travers Garvin is at KKR, a private equity firm that has, in the last few years, started investing in infrastructure and has some interesting case studies to describe to us. And we have a sort of a tag team here from ITC Corporation, which is the largest independent transmission company in America, covering much of, I'll call it, the North Midwest. That's a way of providing it: Michigan, Minnesota, Kansas, Iowa, and represented by Matt Carstens, who lives in Iowa, and Jenny Diana, who's in Detroit, and they will each give a case study of the difficulties of trying to permit new power lines, including power lines that are essential if we want to have renewable energy, to go from the new sources back to the metropolitan area. So I'm looking forward to all the presentations. Don, why don't you start us off?
Thank you, Philip. I want to try to talk primarily about why we have the problem, or why we have the issue of multiple overlapping authorities, and then what we might be able to do about it. I do think there's a significant problem in this area, and I won't belabor it, but one example is provided by the Cape Wind project, which is the first offshore wind project that would have saved 7 million tons of CO2 so far, but after 10 years, it's still in the permitting process. The most recent development is a D.C. Circuit decision that the FAA didn't pay enough attention to the possible effect on the landing routes for a little airport nearby. Another case that I have followed involves a fertilizer company, Mosaic, one of the largest fertilizer companies, that spent 5 years trying to get permission to expand its existing fertilizer mining operation in Florida. So we do have, I think, a problem of delay. Nick said earlier, from the standpoint of the OECD, that the holy grail of this would be, of speeding things up, would be one-stop shopping. I think that's not practical in the American legal system for some reasons that I'll discuss, but it was kind of encapsulated by a wonderful comment made around the turn of the previous century by Walter Bagehot, who was the first editor of The Economist, and many people call him the founder of political science. He said the theory of the English Constitution is to have a single authority and make it excellent. The theory of the American Constitution is to have a multiplicity of authorities in the hope that their numerosity will make up for their mediocrity. That, with typical European modesty, captures the difference between the U.S. approach and the European approach. Americans, with the exception of occasional exceptions like Obamacare, tend to be very suspicious of government. And we try to compensate for that by having a multiplicity of authorities, which is sometimes called checks and balances. This is in the concept of engineering, this is called redundancy. If you have imperfect components, one of the ways to build a system that is stronger than any individual component is to combine them together into a complex system. So when I used to be a pilot flying small planes, I was very glad to know that I had 2 spark plugs and 2 oil pans in my engine. But of course, you could, in theory, build in 6 spark plugs or 8 spark plugs or an infinite number of spark plugs. So at some point, as Senator King said earlier, you have to strike a balance between the benefits of having additional reviews and the costs of doing that. In the environmental area, particularly with regard to environmental reviews, which was the topic of the previous panel, but it's the area I know best, we have seven different quality control mechanisms to all make sure that all the environmental effects get considered. First of all, we have the very detailed CEQ regulations. Secondly, as a practical matter, environmental impact statements are written by consultants who have a reputational interest in making sure that everything is covered. Then it goes through a public comment process. The agency, which is the deciding agency, then reviews and makes decisions as to whether or not the statement is adequate. EPA then comments on the adequacy of the environmental review. It's done that since 1970 as an independent expert reviewing the environmental impact. And then it goes to the district court, and then it goes to the Court of Appeals. So we have 7 different quality control processes. Now, part of my thesis is that that's too many, that the benefits of having 7 spark plugs rather than 2 or 3 spark plugs are outweighed by the cost to the process. Richard Lazarus at Harvard has said that the reason we have so many of these checks and balances is what he calls the tragedy of distrust. I think that's a little bit too optimistic, because it suggests that somebody actually designed this system. And as Philip, I think, rather brilliantly lays out in his forthcoming book, The Rule of Nobody, which I've had the benefit of reading the galleys, the system isn't actually designed. It just grew. It accreted through a series of decisions. And we typically talk about it as if it were designed by a single intelligence or engineer, and I think that's fundamentally misleading. My thesis is that judicial review at the district court and at the Court of Appeals adds very little to the quality of actual environmental decisions, but it increases the costs very dramatically, primarily in terms of the defensive medicine that my previous question asked about. It's not actually designed into the system. It just happened. Early in my career, for a book that I never got around to writing, I interviewed the legislative aide for Henry Jackson, who wrote I know who Linton Caldwell is, but he didn't write the bill. And I asked about judicial review of EISs, and Jackson's aide said, well, we thought about it, and we hoped that it might happen. And I said, well, why didn't you put it into the bill? And he said, because if we put it in the bill, it never would have passed. So judicial review of environmental impact statements for adequacy is, I think, in some ways an unforeseen and unnecessary consequence. Also, in the context of reviewing individual cases, it's very difficult to make the kind of comprehensive planning decisions because you only see the issue in that particular case that hasn't been considered. You don't really see the costs overall of requiring that to be considered. This is well known in the literature. The legal literature for many years has talked about how case-by-case litigation is not well suited to what are called polycentric controversies, and this is a very good example of it. So if we were to look at the additional benefits to the environment from judicial review after this elaborate administrative process, we'd probably conclude that the game is not worth the candle. In part, it's because judges are not expert, and in part, it's because the decisions are very political. There's a study by the Environmental Law Institute called Judging NEPA in 2002 that points out that judges appointed by Democratic presidents grant a preliminary injunction 60% of the time. Those appointed by Republican presidents do 28% of the time, and those appointed by George W. Bush do 16% of the time. Bob Nordhaus said, well, that just shows that the Democratic judges are smarter. But I think what it shows is that this isn't really an expert process of assessment. It's a process in which people are making symbolic gestures of how much concern they have for the environment. Now, I do recognize that it would be very difficult at this point to amend the statute to eliminate judicial review. But there is, I think, a narrower remedy that is actually quite practical, and that is to enforce the existing rules with regard to organizational standing more stringently. One of the grounds on which an organization has standing is that the organization is actually devoted to the issues that it's raising. And one of the anomalies, or committed, one of its purposes is to advance those issues. There are many instances in which those who sue challenging NEPA statements are not at all interested in protecting the environment. They're interested in stopping the project. And those are really quite different because, as George Frampton pointed out in the previous panel, the NEPA process is supposed to be about environmental analysis. Just one example, a few years ago I represented Walmart in New York State, under the New York State equivalent of NEPA. There was a group called Citizens to Stop Walmart that was using the New York State statute to oppose the renovation of a dilapidated store in a mall as part of a renewal project. They made it very clear that their opposition had nothing to do with the environment. They were objecting to Walmart's non-union policies, and if it were a Target store or a Kmart store or any other store, they thought it was fine, but if it was going to be a Walmart, they objected to it. They delayed the project for several years. It cost over $400,000 to litigate the case. We won, in quotation marks, at every level. But this is an example, I think, of the way in which judicial review of environmental impact statements really doesn't improve the quality of decisions. It simply gives a very valuable bargaining chip to those who are opposed to the project for reasons that have nothing to do with its environmental effects.
Great. Thank you. Steve?
Thank you, Philip, and thank you for the invitation to join you today. Good morning. I think the reason I was invited to speak on this panel is to give some examples of success stories, and I'm really pleased to do that because despite the challenges, and there are many, I don't disagree with anything that has been said today, in terms of process, jurisdiction, just the multifaceted and very complex nature of large infrastructure permitting in this country. I also agree with the proposition that changing the law, the underlying laws that we're talking about, whether it's NEPA, the environmental laws, or other jurisdictional statutes that affect outcomes here, is not a realistic solution or possibility, at least in the near term. And so I want to tell you a little bit about what we did at the Department of the Interior to permit large utility-scale renewable energy projects and transmission projects on public lands. As those of you who are in the industry know, even projects permitted largely on private land almost inevitably have a federal nexus at some level, whether it's wildlife, water. We've talked about Corp 404 permits. And so there is this inevitable overlap in jurisdictional authority between state and federal authorities, sometimes local authorities, that can bring a project to a quick standstill. But as you know, President Obama ran in part on a campaign, a promise on the renewable energy and climate side to increase the renewable energy generated in this country by a factor of 2. We did that in the first term. There were about 36,000 megawatts of wind, solar, and geothermal at a utility scale in 2009. At the end of last year, there were about 72,000 megawatts, and he again pledged to double that in June of this year in the Climate Action Plan. How could he possibly make that commitment, given the challenges of permitting large infrastructure projects like this? So I think we have a good government story here, and we really did, through strike teams, through SWAT teams, through strong leadership and accountability at very senior levels of government across 9 agencies that have authority for permitting transmission or renewable energy generation, we really cracked the nut. And I don't think the story has been told adequately. To be sure, there are still outstanding challenges. I don't mean to suggest we have solved the problem. At the end of the day, I think it was a function and consequence of strong leadership. And that of course, changes with each successive appointment, each successive cabinet secretary or assistant secretary or deputy secretary. But Ken Salazar, my former boss, I worked for him for 9 years, and if I learned anything about Ken Salazar, it is that results matter. And that's not to say we cut corners or that we made decisions and then justified them after the fact. I was very grateful for the endorsement of NEPA and agree with the proposition that NEPA is our friend here, if properly applied. But what we did instead is identify priority projects. We did create what we call the fast track project system or list at the Bureau of Land Management, and identified those priority projects that we thought could be permitted within a relevant time frame, in this case to be eligible for some of the very important financial incentives under the Recovery Act. And in California, just to point to one example, I was glad to see the slide on the geothermal permitting project and the I don't know how many, 300 permits that might be required not only under federal law but state and local law to permit a project in California. California had not permitted a thermal energy project in 20 or 30 years. No one thought it was possible for California to meet its very aggressive renewable energy standard within state resources. But in 3 years, we permitted over 10,000 megawatts of projects in California alone. We permitted 41 utility-scale renewable energy projects in the Southwest, and about 2,000 miles of transmission that crossed public lands. And no one thought that was possible, but it was the result of a very high-level partnership between Governor Schwarzenegger, Ken Salazar, of course, Stephen Chu and his staff, Governor Vilsack, Nancy Sutley was very helpful. We essentially brought together, through MOUs and otherwise, the senior leadership of the government writ large, across federal government and state governments, and aligned our priorities, worked together to troubleshoot issues, and move projects forward. I'm happy to say we have a 100% success rate defending those decisions in court. And so in addition to good NEPA documents and good decisions, better outcomes in many cases, we were successful. But let me just point to a couple of challenges that remain, because I think that's a fleeting success story if we don't take some of the lessons learned and incorporate them either into new guidance or policies and procedures at the federal government or new statutes and regulations. A transmission line is a good example of a large linear infrastructure project that crosses multiple jurisdictions, and clearly if the line doesn't line up when it crosses a boundary between Wyoming and Idaho, for example, you defeat the purpose of the project. And in Idaho, Philip and I were talking about this a couple of weeks ago, the siting authority in Idaho is delegated to the counties. So the department just 2 weeks ago announced a record of decision for a 1,000-mile high-voltage transmission line from Wyoming to Idaho, the Gateway West project, essential to getting wind resources onto the grid in the Pacific Northwest. We permitted the project on the eastern segment across Wyoming and into Idaho. but didn't complete the permitting on the Idaho side of the line because the counties couldn't agree where to site it. And that in that case, the first segment is a viable segment, and there's a viable justification and commercial need for it. But we were stymied by the local authorities in Idaho, and the governor's office was very helpful, but also responsive to those local concerns, and so we just didn't get that one completed. But it's an example, I think, of this point. The rules of the road are often written at the state and local level. So despite the overlying federalism and federal authority, in many cases the rules of the road are written at the state level. The second point, and I just want to reiterate, it's been made already today, so I won't belabor it. The DOE is working on a very robust pre-application procedure analogous to the FERC procedure for natural gas pipeline siting. And I think that'll be very helpful, and it just goes to the point that a number of people have made, that early consultation with the relevant permitting authorities and agencies and stakeholders in the planning stages of a process, a project, is critically important. Sitting down with BLM, the Fish and Wildlife Service, the Park Service, and other state and local authorities, and describing the project, identifying the potential obstacles early is often very helpful and can save a lot of time at the back end. George Frampton made that point earlier, but I just wanted to reiterate that. I'm out of time, so I'll stop and take questions later.
Great, thank you. Lynn?
Yeah, thank you very
Yeah,
much.
you need a microphone.
You need a mic here. Thank you very much. I'm reminded as we have this discussion of the words of Bertrand Russell, who once said, sometimes it's important to hang a question mark on things long taken for granted. And I think that's relevant as we think about infrastructure and how to conceive, plan, design, review, and decide. And I want to look at some of the institutional and decision challenges, and then, like Steve Black, actually offer up some of the real-world actionable remedies to many of the issues that have been raised in the earlier panel and now. But let's remind us of that institutional and decisional setting. We've alluded to it, but there are multiple jurisdictions engaged and responsible, and that includes federal, tribal, state, local, and one we haven't often mentioned, also special districts. Multiple agencies, so even at the federal level, of course, one may have the Fish and Wildlife Service, the Bureau of Land Management, the Forest Service, EPA, NOAA, whatever the setting might entail. And so multiple agencies at the federal, state, and local level. Even within a single agency, inconsistent decision criteria and processes often unfold. And then, of course, someone this morning alluded to the fact that we have single-purpose laws in a very interconnected world. Now, I'm going to offer up my own holy grail, and I think that holy grail is faster, better, smarter decisions and better outcomes. And those better outcomes include the environmental, economic, and community. So thinking about the solutions that would yield that holy grail, I think also requires contemplating the context a bit and taking a closer look at the target. So I want to take a look at that target for a moment, and this is partly prompted by the comments of some who have hoped for the prospect of one-stop shop, etc. First of all, we use this big word infrastructure, but not all infrastructure is the same, as we all know. There are great differences in scale. Pipelines, of course, are long and linear. Energy facilities may be site-specific, some large, some much more bounded. There are wide differences in form and function. Ports are very different from hydro facilities, are very different from pipelines, wind energy facilities, and so forth. And thus, that means there are different mixes of expertise, different clusters of players, different environmental impacts, and different performance considerations. Thus, to my mind, there's no single governance solution and no silver bullet here. I worry about the one ultimate decision czar because of the complexities and because of the many knowledges that come into play in good decision making. But nonetheless, despite those differences among different infrastructure types, I think there's some shared components of good decision making. And shared components of process. So all infrastructure decision-making involves, first and foremost, some decisions about siting. Where the heck are we putting this? There are decisions pertaining to design and materials, and then, of course, one isn't done when one gets the thing built. There are also operational considerations that have environmental, community, and other potential implications. So how do we yield better, cleaner, smarter, timely decisions? I want to focus on 4 key components, and in many ways these link both process and structure, getting to some of the institutional questions. First component or first concept I want to raise is what the Nature Conservancy is increasingly referring to as development by design or smart development. Several of you have alluded to this, particularly in the questions and answers, but essentially this development by design suggests you got to start up front, way at the beginning, with a pre-identification of suitable sites. Framework is a multi-participant kind of cross-jurisdictional large landscape look at the spatial setting. That larger look allows you to say, where are the key environmental values? Where are the critically sensitive environmental resources? How do we site or place infrastructure to avoid those critical places or minimize impacts? Let me give you a counterexample of where that was not done. While I was at the Interior Department, there was a proposal to build a commercial space launch site, and those looking at the opportunity said, well, gee, here's a good spot. Let's stick it right in the middle of Merritt Island National Wildlife Refuge. Well, perhaps they would have succeeded, but you know, if you took a larger spatial scale look at this, you saw that, in fact, there were some abandoned space launch sites already paved over with facilities in place. Well, maybe that might have been a better starting point. In this particular instance, we didn't get past that starting point because I took one look at that and went to the NASA administrator and said, you know, you'll be at this for 50 years and you still won't get it done. But anyway, the point is upfront site selection, but site selection not by looking narrowly, but by taking a broad view at the holistic landscape and the different possibilities and overlap of the potential for siting and your critical places. Now, this isn't hypothetical, and this brings me to the institutional construct. It's not perfect. It's a work in progress. Steve was involved in this. We actually set some of the predicate for it, and that is the West-Wide Energy Corridor, an 11-state joint federal-state effort to try and look large landscape, look at those critical resources and say, where could you, where might be the best pathways to put pipelines for oil, gas, et cetera. Used a single programmatic EIS for that, engaged multiple cross-jurisdictional agencies. Now, as Steve well knows, that's a starting point. You do your programmatic EIS, you look at that big scale, you identify those potential corridor pathways, then you still get to the Idaho actual decision making. But it's a good starting point, and it advances the prospect that you're going to successfully cite, and without labored critique of the environmental impacts and what you're doing. Similar effort, by the way, with the California Desert Renewable Energy Conservation Plan. Again, here, institutionally think about this, a tight joint state-federal planning process across 23 million acres. Large landscape, multiple agencies, federal and state. And again, looking at that smart development approach. Where are the critical resources? Where are the critical environmental impacts? How can we avoid them and or minimize them as we think about the areas most suitable for siting? Now, this brings me to another piece in the decision process, and one that I think needs to be dramatically moved forward rather than left as the afterthought at the end, and this pertains to mitigation. If you look at mitigation and infrastructure projects, most of the thought about in mitigation has typically occurred project by project and at the very end of the game. Oops, here are our impacts, now let's mitigate. Out of that process, you get what I call sort of dot and twiddle mitigations. You know, plant a new bush here, put a little fake wetland there. You know, not very effective, but also very costly, and also adds a lot of time chunk to the end of the process because now you're just trying to mitigate what the process has indicated you need to do. So what we are seeing that's inefficient, ineffective, and it's expensive. So we're seeing the emergence of the pre-identification of key impacts and then the establishment up front of mitigation banks that supply at large scale a bundle of offset credits. And by the way, not one set for species and another set for one, but banks that actually can combine and provide a multiple set of benefits, and then the offset credits can be purchased by the project developer as needed. That concept yields much better prospects for better environmental results, but also much faster mitigation response. And it gives you the opportunity to know up front what your opportunities for mitigation might be. Now I want to turn to NEPA. I'm going to agree with Steve here. For all that we've heard about NEPA this morning, and for all that we pull our hair out sometimes in its implementation, NEPA, the law, actually has the opportunity to be a fulcrum for coordination rather than fractionation. Potential to greatly expand the use, and several people have mentioned it, of early consultation. But I want to flag something that not too many folks today have mentioned, and that is much stronger use of the tool of cooperating agency status. Now that, embedded in NEPA, gives a platform for the action agency to bring in all those federal, state, local, tribal, special district people right at the beginning in the scoping process and engage in a single joint EIS process, so you don't have the discussion that we've had, or the prospect that we heard earlier of feds do their review and then you get the state. You do it all at once. And NEPA actually, look at the law, provides a platform to do that. It's insufficiently and not always frequently used, or not used necessarily robustly. Now I want to get to a next concept, and it's one that Steve also mentioned, and it's one that we used to good effect while I was at the Interior Department, and that is the strike team concept. I mean, if you go back and think of the fact that different kinds of infrastructure have different kinds of players, it suggests that a one-stop shop remedy, or having the infrastructure czar, may be problematic in terms of bringing together the right knowledge sets and the right folks in the right place for all times and purposes. Strike team concept lets you say, what's the infrastructure project? Let's cluster the right players together. Let's get an entity that is going to really focus on this. Get your timeline, your actions that need to be done, and by golly, focus to get those actions undertaken in a timely way. It's a nimble kind of process. It allows the prospect of setting deadlines, getting more rapid but good review, and then approval. Now I want to mention one case, and in some ways it was both a positive and a negative example, and that is in Everglades Restoration, as we tried to get the Tamiami Trail bridging conceived, designed, built, and in place. We had Florida Department of Transportation, U.S. Department of Justice, Florida Power and Light, Department of Interior that included both Fish and Wildlife Service as well as the Park Service, some USGR engagement, Department of Environment in Florida, et cetera, et cetera, et cetera. Many different things that needed to be done to make this all happen. I created a SWAT team. We created a matrix with all the activities that we needed to do and who was responsible for the final decision on those activities. And we met every single week for essentially a year, ticking through those things. Okay, we need a highway easement deed. Who's got to get that? If justice was standing in our way, I'd call the deputy secretary, get that done. Now, we actually got that all done with the goal of getting the contract out before we left in 2008, December. Unfortunately, we got sued. 4 different lawsuits, all by essentially the Miccosukee tribe. Ultimately, all of those suits were overcome. The courts ruled against the tribe, and the new administration was able to cut the ribbon. So I do view that as a success, because ultimately it got done, and it got done in a relatively timely fashion. From the moment that we figured out, by golly, we got the money now, we can do this. We got the NEPA done. We got all those different items in the matrix taken care of, and the project is in fact now built. And that occurred in a relatively short, just couple-year time frame from beginning to end. So these concepts aren't revolutionary, but they have the virtue of being doable, and they do make a difference. Pair those with the concepts of the first panel about transparency, clear timelines, clear performance metrics, and I think rather than these successes being episodic, I think they could be more frequent.
Great, thank you. Travers?
Morning, everyone. Travers, Garvin. I'm with KKR. I've been at the firm for about 5 years, but the firm itself is around for about 37. I've been making investments in the energy and infra space for a long time. I was asked this morning to speak a little bit about our experience with a public-private partnership in the city of Bayonne to own and operate their municipal water system. I'd open with the observation that if you're going to have a P3, it makes sense to have very good partners, and we were lucky that in this case we had two. The first is a company called United Water. They're a New Jersey-based company that's been running water systems in the state for over 100 years. The second, and this is key, and it goes to something that's been spoken about often this morning in terms of political leadership, was actually our counterparty, which was the mayor, Democratic Mayor Mark Smith, who was a real force for action, A, in getting the deal done, and then B, helping us get through the regulatory process. So I thought it might make sense to begin with a little bit of background about Bayonne's situation before the partnership took place. First, the city and the system had significant debt. Second, the city was actually having trouble hiring people that had the right qualifications and certifications to run the system. And third, the system itself was beginning to, I don't want to say break down, but showing its age in terms of a lack of maintenance and upkeep over the years. So the proposed solution was, again, a public-private partnership where KKR and United Water invested $150 million into the city to acquire a 40-year concession to own and operate the system. The benefits to the city were, one, they eliminated all the debt associated with running the municipality. Two, United Water could bring in its stable of folks that were certified to run the system, so it took care of that problem. And finally, and I think this is key, the agreement requires annual maintenance and upkeep. You know, I think the interesting thing about, particularly water infrastructure is you don't see it. So you don't know when it's sort of breaking down, eroding, disappearing. And so, candidly, and the mayor would admit this in a way that he was paying for the sins of his fathers, if it comes down to paying the police or the fire department or teachers or wherever it may be, or putting more money into the pipes, you'll probably do the thing that's more visible, more noticeable. So the interesting thing I think about this agreement is it actually commits us contractually each year to investing over the life of the contract about $110 million into the upkeep of the system. So that's the basics of the deal. I think in terms of the regulatory process, it's funny. I think I was envisioned to be a bit of a negative story, but now after listening to all this morning's presentations, I'm starting to feel like maybe we came out easy and maybe it was a lot better than we thought. So the local municipal authority, the BMUA, the Bayonne Municipal Utilities Association, was very much behind the deal, was very supportive. It actually passed unanimously with one abstention at the local level. The state level was more complicated, as you might expect. But again, compared to, and I'm going to check my notes, the Bayonne Bridge, which apparently required 47 permits from 19 different agencies, I'm starting to feel embarrassed. We needed review by 3 state agencies. Now, what I will say is, and I can go through them, the first is the New Jersey Board of Public Utilities, which was basically making sure that the rates were reasonable to the ratepayers. Second, the local finance board, which basically was making sure that the local city wasn't making a bad deal, wasn't selling the assets on the cheap, or wasn't sort of doing an inside job. The third was the Department of Environmental Protection. Not surprisingly, wanted to make sure that they weren't selling the system to 2 guys with a pickup truck, that it was someone accredited, somebody who knew what they were doing and could maintain the standards that were required. So the regulatory process was reasonably straightforward, and we're not opposed in any way, shape, or form to regulation. I think what we did run into a little bit was this problem of the rule of no one that's been referenced before. In terms of, there were hiccups and there were challenges where, no one sort of owned the process, and there'd be delays, or one group would have to wait on another, and there was no way to sort of force action, which is frustrating if you're trying to get a deal done. I would say, despite the reasonably straightforward nature of the approval process, there were two notable challenges during this process. First, at one point, one of the state agencies, as a precondition to approving the deal, wanted to eliminate another agency that existed, which was actually our counterparty, which made it, we didn't want to get anywhere near in between a jurisdictional turf battle and all the rest, but it made it quite challenging to try to navigate that and make both regulatory parties happy. So the next hiccup was essentially all the state reviews had happened. Everything was good. We were in a good place, ready to go. Financing's lined up. And we had this thing come out of the blue where someone who didn't actually have sort of authority over the deal, but it was actually the supplier of the water to the system, also another state agency, got themselves a little bit hung up on a very technical issue around the bonds and whether or not, how the liability would work with the bonds. And they had to appeal for a waiver to another state agency. So my colleague laughs, he thought, no problem, we'll call them up, we'll explain the situation, this will be straightforward, we'll get going. The challenge was, and the second agency, candidly, was ready to issue the waiver. The first agency essentially got cold feet, wanted to make sure they were doubly protected, so they hired a law firm to run the whole process. It ended up, not terrible, but when you're trying to get a deal done and you think this thing might fall apart, trading letters and legal opinions for the next 3 or 4 weeks, which we were kind of nervous that our financing might fall through during that period. So again, I'm going to be quick. Perhaps I'll stop there. I'd say, my takeaway from all this is that, the private sector is very eager to invest with the public sector to build infrastructure. We know the country needs it. It can be challenging to do so. Hopefully, an outgrowth of today's conversation is we can lay the groundwork for an easier path to do that.
Great, thank you, Travers. And batting cleanup is a duo. Travers, Garvin, and Jenny Dana. How are you guys who's going first?
I'm going to go first.
Okay, typical Matt, typical guy behavior.
Just get it over with.
Yeah.
But
I once had to have a gamma globulin shot in 1955, which is a horse shot. But I had 2 older brothers, and we all had to go because we'd been exposed to someone with polio. And the doctor said, "Who's going first?" My brother's supposed to push me into the door. He is.
I'm happy to go first. Thanks, Phil, and thanks for having ITC here. ITC, as you mentioned in the introduction, is the nation's largest independent transmission company, and what that means is we don't do generation or distribution of electricity. We focus solely on the high voltage transmission, the large lines you see, like those. And last night when we were talking, you wanted me to mention that we were born out of, actually with Travers's organizations or entities' help, KKR, buying transmission assets from integrated utilities that didn't seem to want them anymore, or at least had neglected them to the point where they had to invest significant amounts of money to update them and opted instead to have us do it. So we started with DTE's facilities at their transmission assets in southeast Michigan, then spread to most of the rest of the lower peninsula with Consumer Energy, and then purchased Alliant Energy's subsidiary, Interstate Power and Light, in Iowa and Minnesota, which is how I got involved eventually. I'm in Cedar Rapids, Iowa, and Jenny is in Novi. And together, we both work in the capital projects group of the legal department for ITC. So I like to think of us as being counsel for the project. And I hope that we can offer at least a kind of boots on the ground view of some of the redundancies that we have to go through, particularly as to improving need for a project. Because we do cite over multiple jurisdictions and sometimes across multiple jurisdictions. So actually, Steve, your comments about citing between jurisdictions is we do have experience with that too. Some of these are some of our active projects to some of the larger ones. The MVP references are all from MISO, which is one of our RTOs that we work with, and I'll talk about in a second. The MVPs are multiple value projects especially bringing in renewable energy into the grid and also bolstering reliability. That was the main justification for some of those projects, and those are the larger ones that we're working on right now. The Thumb Loop is actually an MVP project too, MVP 13.
It's the first MISO MVP project.
I guess to tell people what the initials stand for, because this is.
Multi-value project,
Right.
yeah. So this is an overview of the process that we go through. If you look at the ruler, the timeline varies quite a bit, but the planning segment can last for up to decades. Remember, there's a project that we recently completed in June that had been planned for decades, and the need for which was well aware to the participants and the utilities, but no one could no one would want to take on the project to get it built. And one of the conditions for our approval, our regulatory approval, when we acquired the IPL assets in Iowa and Minnesota, was Minnesota made us promise that we would build the project. So anyway, that first stage is planning that involves, and I'll talk a little bit about this, just preparing something for the RTO, which is the regional transmission organization, the planning organization that we answer to. Submitting that, and then getting community, once that gets approved by the RTO, getting community engagement. And Bob Yarrow mentioned the idea of getting anticipatory groups or anticipating objections or concerns. And that's part of we're a fairly young company. We've only been around for 10 years. Part of our process is really developed so that we are going to environmental groups and other stakeholders after the project is approved by the RTO, but before we go and seek regulatory approval, to try to get buy-in. This is the route that we are thinking about. It's not written in stone. What concerns do you have about that? What do you know about that? And we also do that with open houses in the project area so that we can get input from landowners about what wells may be out there, what historic properties may be out there, anything that might slow down the process. And then continuing on. So as I said, the first part can take decades, but once RTO, the Regional Transmission Organization, approves the project, it takes, on average, 6 to 7 years to get the project built. This is, Jenny's going to talk about some of these. These are just some of the areas where we have to establish need, and we have the redundancy of what we have to show in order to get a project approved. The RTOs I just mentioned, that's the first step. The RTOs, in case you're not familiar, very briefly, are subject to FERC guidelines, are essentially made up of utilities in a region, and the idea is that under the FERC guidelines, someone who's taking service across that region doesn't have to pay a pancake rate, doesn't have to pay an additive from each utility as they go from one to another in taking service. These are the RTOs. It's a fairly accurate map. MISO is in green. MISO is the Mid-Continent Independent System Operator. That's the main one that we work with. Also, the light blue is the Southwest Power Pool. Both of those organizations essentially approved the project after one of the transmission operators or one of us propose it. And so it's a top-down, bottom-up process, illustrated here a little bit. It's a rough schematic, but essentially, once a need is identified by a transmission operator, MISO takes that and then puts it through what you see in the right box, the project evaluation, where the need is proven through a series of modeling and weighed against other projects that may be redundant. The end result is that MISO, or Southwest Power Pool, gives the stamp of approval that this is, in fact, a project that will address a specific need, whether it's generation interconnection or reliability or multiple uses as in MVPs. But it's a long and extensive process that it does establish that need, and it's done by organization that does have a very high level of competence in making that determination. I'll turn it over to Jenny.
Mike.
Yep.
Thanks, Matt. So, as Matt addressed, essentially, FERC delegates authority to the RTOs to spot out the issues and identify where there's need for project. And through that sort of vetting process, the need is established by MISO or the relevant RTO. And then sort of it gets handed over once the project is approved, and it's, at ITC, it comes to me or my group where it's considered a live project, and then we would go from there to get the state regulatory approvals. And this slide just shows a little snapshot or representation of some of the types of approvals that are required in various jurisdictions. And as you can tell, it's not uniform state to state. Certain states require more than one. In Michigan, specifically, requires one approval for a line that consists of over 5 miles and 345,000 volts or higher. That is when you would be absolutely required to get a CPCN, which is a certificate of need. It takes about, I would say, a year. It can take up to a year to prepare the application to file. The application consists of multiple elements, many of which are driven by the statute. And some certain things that are incorporated are written testimony, environmental testimony, heavy emphasis on the need, obviously, health and safety issues, and we also have routing experts that come and propose a preferred route and an alternate route, which is required by the statute. Once the application is submitted to the Michigan Public Service Commission, which is the governing body that reviews these applications, they have up to 1 year make a decision on whether to grant the certificate or deny it. If we're successful and we do obtain the state regulatory approvals needed, we then sort of turn again to the state permitting process, which we've talked about a lot today. And of course, it depends on the different jurisdictions, which permits are required, both at the state level and at the local level. One interesting nuance about some of the state regulatory approvals that we obtain is in certain jurisdictions, that approval would trump a local ordinance that conflicts with what was included and what was granted in our certificate from the state. So I guess an example of that is if a local jurisdiction, like a township, had a zoning ordinance that restricted the construction of a substation within a particular zone of the township, our certificate would trump that, and we would be allowed to construct the substation where otherwise it would not be able to be built.
Although that's not consistent across our whole footprint. Some states, we do get that preemption, and some states we do not.
Right. In Michigan, we would get that, and I think you said in Minnesota we wouldn't.
Right. And in Iowa, we would not. Actually, Minnesota we would. It's more extensive, but in Iowa, we still have to go to the municipalities and get separate approval.
Right. And it's interesting there, too, because a lot of times the local governments really need to be educated on what that means. I mean, it's definitely something where you tread lightly on because they really don't understand why their local laws may not be enforceable in a particular instance. So it's something that, really requires, like what Matt said, going into the communities beforehand and educating the local municipalities about the issues. And this is just a snapshot of some of the many permits that we have to obtain in siting these lines.
Can you go back to that?
Sure.
Is that a separate application with each one of those?
It's a separate permitting application for each one. In various townships, some are at the county level, some are at the township level, some are at the state level.
Federal.
federal railroads, yep.
And what happens if one of those decides they don't want to give you the permit?
Then there's delay, which adds cost and time,
Or it
Okay.
kills the project.
or it kills the project.
Then just delay it.
Right.
Okay, sorry.
Let's see. So after we obtain, after we obtain the state regulatory approvals and the permits, of course, there is always the issue of acquiring the proper land rights in order to build the transmission lines. And we do that, first we start, and our primary, preference is to acquire the right-of-way on a voluntary basis. Of course, we can't be successful 100% of the time. There are oftentimes holdouts on various lines where landowners, for their own reasons, refuse to grant us the easement on a voluntary basis, and that's when we have to invoke our condemnation authority. ITC generally possesses eminent domain powers in the various jurisdictions where we have infrastructure. However, the eminent domain processes vary by jurisdiction, and some jurisdictions are more condemning agency friendly and others are not. Michigan, for example, is not friendly.
How long does that take?
Well, in Michigan, and I'll get into this now, we're governed by the statute. Eminent domain is typically a statutory, animal when it comes to the process and procedures. In Michigan, it's the Uniform Condemnation Procedures Act. We are required, before we can initiate a condemnation complaint, to file or submit a good faith written offer to a landowner, which is generally based on what ITC believes after getting an appraisal of the property to be estimated just compensation. And the two key elements in Michigan to condemn are proving the necessity. So again, we've already proven the necessity at the federal RTO level. We have to prove it up again at the state level. And then now here we are proving it up to the judicial local level. And so we would file a complaint, like I said, after we submit a good faith written offer. The landowner has the ability to challenge necessity. They have to make that challenge depending on how they were served with the complaint, 21 or 28 days after they are served with a complaint, at which time, if they challenge, it can delay up to 6 months. Now, under the statute, a judge determines necessity and handles those types of challenges. And technically, under the statute, they are restricted by a certain time frame to hear these challenges, but a lot of deference is given to the landowners in terms of scheduling the hearings in front of the judge to determine the necessity. So, again, another way to delay the project is to challenge, which takes, again, time and money in dealing with the challenge. And the statute is written in such a way that if we have a certificate of need, then it's supposed to be deemed necessary in a condemnation action. However, there's always challenges. Even if we have a certificate, they still, the landowners still challenge. And really, it's a procedural aspect that takes time. Just briefly, in Kansas, Kansas is a bit more condemning agency friendly. We're governed there by the Kansas Eminent Domain Procedure Act. And in Kansas, you need the state regulatory approval, and your complaint basically has to allege that you do have the state regulatory approval, that you're condemning for a lawful purpose, and that you are paying the landowner just compensation. And they will allow the property to be condemned.
I'm just going to, I'm not going to go into detail about Iowa and Minnesota, but Steve mentioned the project that he's working on between Wyoming and Idaho and the different processes that exist between the two different states, and especially if you're trying to build across the two. In Iowa and Minnesota, we have the MVP3 project coming down from southwest Minnesota and into northeast Iowa and eventually into the grid, the larger grid. Sorry. Iowa and Minnesota have a similar contrast. In Iowa, to start a process, you have to have a public information meeting, and then you are free to go out and acquire right-of-way. You essentially pick the route. You have one route that you propose, and you go out and you start acquiring right-of-way easements all along, and then if you get 100%, great. Otherwise, you have to apply for eminent domain. And by the time you've applied for eminent domain and the franchise, the approval for the project, you've already essentially picked the route. Whereas in Minnesota, you have to propose 2 different routes, and ultimately the Public Utility Commission, after going through the Department of Commerce process, the environmental permitting process, the PUC, the Public Utility Commission, will pick a route, and we're hoping that they pick a route that matches up in Iowa. But obviously we have contingencies, but we'll hope that goes well. I'm sure we'll make it work. But so again, we go through we demonstrate need over a series of entities or organizations: the Regional Transmission Organization, the state regulatory authority, and then finally the court system. And to Don Elliott's point about the judicial review that comes last in terms of eminent domain, that it truly is probably the lowest level of competence if we're looking at the need for a project after it's been through the RTO planning process, after it's been through the state regulatory process. All those subject matter experts really have a far greater knowledge and competence of what we're doing and what the landowner and the stakeholder concerns are. It would be helpful if there were a rebuttable presumption, for example, of the need for a project that would not have to be reviewed. I'll take one more contrast and then end. But in Kansas, when judicial review happens, that there's a great amount of deference that's given to the Kansas Corporation Commission, which is the regulatory body that approves a project as to the need for the project. Whereas in Missouri, need has to be proven up in a full evidentiary hearing again, and that can take place at every instance where we go through condemnation.
All right, thank you. I have become admit to being somewhat confused now. The projects I've looked at over the years resemble the things that Senator King discussed, which is a big project that's been approved at some higher level, whether it's a state or federal project, and then gets involved with multiple permitting requirements that, depending on the project, probably for some reason doesn't usually kill the project, although maybe in Cape Wind it's trying to, but delays it for, into tectonic time, basically. And so you were describing in every county in Idaho has to approve the siting of a power line that's an interstate power line that's taking power from wind farms. So my question to any of the panel is, there are obviously legitimate local concerns in large projects, but if you have I'll start with an interstate project, whether it's a power line or something else, if you have an interstate project, what is a sensible process for both engaging local concerns without adding years or longer to the process? I mean, how should it work?
Let me take a stab at that and invite others to join me. I mentioned a pre-application process, and DOE under Section 216 of the Federal Power Act is developing right now a proposed rule that would require an applicant to meet with those county officials, meet with BLM, meet with the Fish and Wildlife Service, the Forest Service in advance, and essentially as proof of concept, identify the potential obstacles to siting a line across those counties. I was interested in looking at the map of the ISOs across the country. I don't know if you noticed, there are no ISOs with the exception of California and Texas in the West. And the federal government owns more than 50% of the land mass in the West. So you're not only dealing with the counties, but you're dealing with the federal government. So a pre-application process at least would help front-load the conversation about the deal breakers and would encourage all of the stakeholders, the project proponent, the federal government, the state government, the county governments, to essentially, either try to get to yes, and if so, do the you then submit your application and then start the NEPA process. But you would have identified showstoppers early and avoided them.
But what would you do about authority? What if some county decides it doesn't want the power line, and 900 counties want the power line?
Yeah, and that's a very good question. In the absence of a change in state or federal law, the answer is simply that's a political process.
What should be the change in law?
So, the FERC natural gas pipeline model is a good example, but it essentially, does create a presumption in favor of a siting decision. There was an attempt to memorialize this in the Energy Policy Act of 2005, giving FERC backstop siting authority for transmission lines, and unfortunately that provision was challenged in court and hasn't proved to be workable. But something like that it gives a project, a single federal agency, in the case of an interstate transmission line that is a federal priority or a federal project, an interstate project, authority to site the line, take the NEPA lead, and in this case overrule a local or state decision.
Don, you want to get a mic?
Yeah, I was going to say, there is some experience with creating larger entities that override local opposition. New York State spent about 20 years unsuccessfully trying to site any kind of thermal energy plants. So they finally passed a statute that all future energy plants would be built by the Power Authority of the state of New York with the ability to override local opposition. But I wanted to make a comment on what Lynn, Scarlett, and Steve Black had said. And this really kind of harkens back to the comment from the person from NRDC. I'm sorry I missed your name. But I thought you made an excellent point about, as this process goes forward, we need to distinguish between anecdote and statistics or real trends. I think part of what Deming teaches us is we ought to study the success stories. So I think it's very interesting to have the relative success stories that Lynn and Steve have shared with us. I think the question, though, is whether or not they're really scalable. That is, to what extent it is a result of the process, and to what extent it is the ability to make the process work when you have really high-level political support. I think that what they demonstrate is it isn't enough if the president gives a speech about the Bayonne Bridge. You need to put together this team with high-level leadership, with the Deputy Secretary of the Department of Interior. And, I've written some articles about implementing the Clean Air Act from when I was there, and I think there are some principles of, ownership and high-level support and a number of things. But one of the things that Lynn said that I thought was very revealing is, I think she said, and if we ran into a glitch, I would just call up the Deputy Attorney General at Justice. Well, to what extent is that scalable? And I think that if what we're saying is that, if you have a major initiative of the administration to increase renewable energy, and you put together a high-level, cabinet-level team, yes, you can eventually get it done, but that may or may not be as a result of the techniques. So I think you have to try to tease out to what extent it's early consultation and to what extent it's high-level political support, and also, frankly, projects that aren't all that controversial. I think that the test case here is projects where there really are people that are fundamentally opposed to them, like the Cape Wind project. And whether or not you can make the system work with regard to those. So I think these are very interesting and important examples, but I think as the process goes forward, we really need to push on, what's driving them. Is it the level of high-level political support, or is it the process?
Yeah, Lynn?
So, yeah, I appreciate that point. I guess one of the reasons I laid out 4 different elements that can contribute to more expeditious but also better resulting outcomes in infrastructure processes, is that in many respects I don't think there is a silver bullet, and I think it is actually a cluster of these things. So there are those occasions when the SWAT team approach, you've got some infrastructure really identified as critical, a high presidential value of getting renewables. You can deploy that SWAT team approach effectively. Is that the only answer? Is that scalable? Is that usable in every circumstance? Clearly not, because obviously it takes a significant investment of time. But at the same time, I do think the first example that I provided, the development by design, smart development concept, that is not about individual people. That is a planning design process where one really looks bigger picture and up front and tries to identify where those critical resources are, and then in your initial siting decision avoid those, and therefore lighten the planning load and the permitting load thereafter. So point number 1 I want to make is certainly there are multiple contributing remedies. But I want to give another example, Phil, to your question about sort of cross-jurisdictional, but only as applied in one particular line item in that list of permits that ITC needed. With the Endangered Species Act, which, after all, as an act with regulatory dimensions, does require in many infrastructure projects that one get an incidental take permit. Historically, that has tended to be done species at a time, individual project at a time, and can be quite laborious. Increasingly, we're seeing the Fish and Wildlife Service move towards large-scale, multi-species habitat conservation planning that include not only listed species, threatened and endangered, but also non-listed species. There is one example of a transmission company in dialogue with the Fish and Wildlife Service over 19 million acres and an entire corridor that cuts across multiple jurisdictions, including transcends Fish and Wildlife Service regional units. And the idea here is to get a single habitat conservation plan, and then as that transmission company works its way down, actually developing out that transmission line, they've essentially got that box already checked. So again, that's just one piece of the permitting picture.
Can I just respond to that? I think it strikes me that there are a number of sort of ideas bubbling out of this. I think the idea of having I guess they call it generic EISs, where you have a broader scale EIS in an area where you can rely on that. The idea of a mitigation bank strikes me as a great idea, where you can simply go and negotiate how much is going into the bank instead of fighting over where the turtle's hole is going to be in George Frampton's desert solar project. But going back to Senator King again, my instinct is in looking at the studies on fraying infrastructure that there are a lot of projects that people would do if there was any measure of certainty that they could get them done in a reasonable period of time, whether they're water project or the decrepit power grid in the Northeast is wasting, 7% of the electricity now? I mean, it's really inexcusable. I mean, how much carbon goes into the air because of that? Those lines all have rights-of-way. You can build a new line. I mean, I don't really understand why much is required to replace a line that's already there. So it does strike me when I look at the stories, the list of ITC things, or I looked at on the Bayonne Bridge, which literally more or less had no environmental impact. The permits from the historic buildings district of New Jersey, the Native American boring rights, even though they weren't covering any new ground or boring anything into the ground to do excavations. I mean, it was literally like a parody of law, not no serious results. It strikes me that if we want to encourage the development of infrastructure in this country, we somehow have to come up with some mechanism, and I can acknowledge that there'll be different solutions for different projects, but there ought to be some mechanism that gives a potential proponent, whether it's public or private, the certainty that they can get an answer. I mean, not that it'll get done, that they can get an answer and then get and get a permit or not within a reasonable time frame. Because if it becomes tectonic, like Cape Wind, then you don't know how many projects are not happening because people just aren't willing to invest the millions of dollars or tens of millions or in advance to do it. So, and I don't know if the gas power lines the gas lines where FERC has exclusive jurisdiction over the siting of gas lines, although not other kinds of lines, is a model or not. But again, I asked, Lynn and Don again and Steve, whether isn't there room here for some, I'll call it not a final answer, but some innovation that would encourage people to start thinking about these big projects. Don, you want to go?
Yeah. Well, I think part of the problem is that there's a loss of perspective, and sometimes values that are only very insignificantly impinged upon by a project are there really isn't any way to waive those, and so some relatively small issue, like in the examples you talked about, ends up impeding a much larger social objective. Diana's examples of NEPA were excellent, of the different processes. I'm also a NEPA nerd, but one that she didn't mention, which I think is significant here, is outright legislative exemptions. And there are over 30 of those where Congress has just come in and said NEPA doesn't apply. And I think that's an indication that the process has some difficulties, because the Congress is saying with lots and lots of things, this is too important for NEPA, we're just going to waive it in its entirety. And I think what's missing is to say the boring rights or the historical preservation issues are not of major centrality in terms of the Bayonne Bridge. There, in lots of areas of law, we have sort of de minimis waivers. We have, this old expression, de minimis non curat lex, the law does not bother with trifles. And that's what we don't have in NEPA. We don't have a way to say this is sufficiently small that we can dispense with it. That's what the scoping process was originally designed to do, but because it's embedded in a litigation context in which it's highly unpredictable whether or not a decision to not pursue something will be a ground for undoing the project through litigation, there's an incentive structure that causes everybody to pursue really very, very small and tangential issues to avoid having a vulnerability in terms of litigation. So it seems to me, Philip, that's what's really kind of missing in the system. And it's, you're about a decider. There's no way to say in the NEPA process, this, and this we know are sufficiently small in terms of this project that we shouldn't bother with them.
Right, but it's complicated here because you've got state and local requirements as well.
Yeah. Phil, to your question, one of our challenges in discussing this is we've got so many interwoven threads. There are lots of things at the federal level that can be done to enhance and expedite the NEPA process and permitting, and indeed, arguably, many of them are being done as we run into these challenges, and we heard Steve talk about some, I mentioned some. But the issue that you're raising about, let's say, transforming the grid in the Northeast, which is antiquated and also, from an environmental standpoint, really generating more emissions than would otherwise need to be. The challenge when you get in that setting is that you really are dealing with local land use decision making, the state constructs, as we heard described by the ITC people, and then there's this overlay of some federal decision making in the process. And to think about a way in which, let's say, the federal government would somehow have some transcending decision would just really trigger all kinds of federalism discussions that get right back to that land use planning kind of rule, local rule. So I understand the hope and the aspiration, but I'm not sure that there's a politically feasible fix. And so that is what causes me to then pivot to some of these more trying to remedy some of these more topically specific challenges in the hopes that the whole then becomes a bit better.
Well, you know, I hear that, but my view is that we're in charge and we can do whatever we want. And if the power grid's wasting 7% of the electricity and emitting tens of millions of extra tons of carbon, that's not a local issue. That's a national issue. It happens to be held up by local balkanization. So it strikes me that part of the conversation, a legitimate part of the conversation, I completely acknowledge the political impossibility, but then again, everything's politically impossible today. We can't even raise the debt ceiling. So to avoid a default. So it seems to me, at least for purposes of this exercise, which is how are we going to rebuild this stuff, we ought to at least address the fact that there's a balkanization that prevents really critical rebuilding of infrastructure to create a sustainable grid going. Why don't we go to some other questions from the audience? We're already out of time. We'll have a few questions. Bob, you have a question?
Yeah, I had just a comment, and I'm thinking about two things. One is that you go back into the history of national infrastructure planning, and it gets to the Constitution. A gentleman named George Washington who insisted on getting the Interstate Commerce Clause in the Constitution, because in the period between his time as Commander in Chief and of the armies and then President, he led an effort to create the C&O Canal, which by its very nature had to be in both parts of it had to be in Virginia, parts of it in Maryland. He couldn't get the states to cooperate under the Articles of Confederation. So he insisted on a federal role in promoting interstate infrastructure systems. Jefferson did a national plan which laid out the major canal and road corridors for the nation, something that was done in the public interest. And I just wonder if for these interstate issues, if there isn't, what's missing is that there isn't enough government in this picture. That in fact there ought to be a public role, and maybe the same thing applies for the states, in identifying the critical needs for these infrastructure investments, for whether they're transmission lines or gas lines and that sort of thing, identifying the need for them, and then actually doing the siting. I guess the other thing, I've been involved tangentially in the process in the UK with High-Speed Rail 2, HS2, which requires a hybrid bill out of Parliament, and the process they go through, because this is public eminent domain of private property across the whole country, that the British government is going through a process of negotiations with each individual property owner along the right-of-way. They're moving the right-of-way in response to the needs of property owners and communities, and then in the end, the Parliament decides on, after literally a couple of years of negotiations over what the best possible right-of-way is, taking stock of local concerns, environmental issues, and so forth. And then it's a matter of national, will of adopting the bill. And shouldn't we be doing something like that here? Because we are talking about national needs. We're talking about eminent domain. It's overriding individual property rights. Or in the West, we're talking about private infrastructure being developed on public lands. I mean, there is a larger public interest here. So, I guess I'm going back to this idea that perhaps there's the need for more planning at the federal and state levels to identify, the needs and the most appropriate rights of way and corridors and so forth, and then the political will then to adopt these corridors and make these things happen. And then they should be franchising the corridors.
Philip, could I just make a comment just on that point, particularly the reference to George Washington and Lynn's comment about a lot of these land use decisions are historically local. There's a very good article in the legal literature by John Macy and Henry Butler called The Matching Principle. And basically their argument is that a decision ought to be made in a polity in which both costs and benefits are felt so that they can be balanced. And sort of we haven't really gotten into the economics of the NIMBY principle, not in my backyard, but it's quite rational for people to oppose something if the costs are going to fall predominantly on them and the benefits are going to be broadly shared with a larger community. So, there is a theoretical framework which allows one to say, if you're going to have a decision made here, it can't be made by people who have an incentive to overvalue the costs because they're going to share the benefits with others. So I think there's an analytical framework in addition to what we're historically given, by which we can assess whether or not what we're given historically is the right place to make these decisions.
No, that's
Thanks. I'm not sure if it was brought up earlier, but yes, Jeffrey Thomas. Based in New Orleans. I'm an attorney and policy consultant that just happens to be in town. I was at a convening on Monday where we were talking about disaster recovery and how to synergize the resources and decision-making around that. Previously, I had served as policy director for the city of New Orleans after Hurricane Katrina. And on large projects, we were able to consolidate the NEPA process, otherwise being conducted separately by HUD and FEMA, when there was a big enough project, and we were able to align both the state and local environmental review processes as well. It was not an easy lift. We had to go up through CEQ to get an advisory opinion, and in fact, we could do that. It was in the context of acquiring 40 acres of land to rebuild a Veterans Affairs medical center. It wasn't codified. It wasn't created as a playbook that could then be subsequently used. There's some talk about it being done post-Sandy for large projects, but again, there's no codified rules. I'm just wondering, based on your respective expertise, is whether that's in fact a model that can be implemented, both in the context of disaster recovery and then more broadly for just peacetime decision making. The argument we had used was that there was this disaster framework that was created so that all these federal agencies that have disaster-related functions would coordinate their decision making, and so they had created the framework so that they could do these consolidated environmental reviews. It just doesn't happen very often, and so I'm wondering if there's something that's yet still needs to be created to make that happen.
Well, it is incredible how, like when the California earthquake happened and the freeways fell down in L.A., somehow or another the will was found to cut through all the approvals and have the freeway rebuilt, I think within a year, basically. I mean, it was an incredible thing. And so crisis, I guess there'd be some version on necessity is the mother of regulatory approval or something, or some version of that. But I don't know, Steve, you have a...
Well, I'm glad that Lynn mentioned the Desert Renewable Energy Conservation Plan. I want to go back to California for a minute because I think it's a partial answer to the question. We attempted, as I mentioned, CEC hadn't done a thermal energy project, a solar project in 30 years. We had 10 in front of us that we permitted in 3 years. We did some joint environmental review documents with the state, and it was very challenging. There were all kinds of legal and other issues that made it very difficult to sort of knit those together, but we did it. We didn't do it in every project. We sort of were learning as we went. But as I said, we've had a 100% success rate defending those documents. But it does depend on the will of the political leadership of, in that case, four different agencies: the BLM, which often had permitting authority for a right-of-way, the U.S. Fish and Wildlife Service, the State Fish and Wildlife Service, or Fish and Game Service, and the California Energy Commission. And we met monthly in Sacramento with those agency heads and 30 or 40 other people from across government, including EPA and DOD and the Corps of Engineers and the Forest Service and the State Land Board, precisely for that reason. But it does take, in that case it wasn't a crisis. Our motivation was meeting Recovery Act goals. But the DRECP is an example of a large 22 million acre habitat conservation plan and natural communities conservation plan under state law that is a combined document. And the beauty of that document, like our solar programmatic, is that we will identify on the landscape what are called development focus areas. So there will literally be polygons on a map that are designed to direct development into the places that have the fewest resource conflicts, the fewest tribal and cultural resource conflicts, the greatest wind and solar potential or geothermal potential. And so it's a very complex planning effort, but it is, I think, the model for future planning. It doesn't quite address a Katrina situation, but it is a good model for energy by design.
Well, it seems to me we should probably move to lunch. But it strikes me in this project that, for this part of the program, that deciding what we need, and what, going to Bob Yarrow's point, deciding what we need is maybe a useful way into these multiple levels of review. If we could decide that we needed to, for anything, rebuild the power grid, have geothermal energy, then it seems to me the next step would say, okay, well, how much will it cost and time will it take to do it in the existing balkanized system, and how much could we save and how much more could we do if we were able to streamline it one way or another, whether it's through a SWAT team or some other thing. If we were able to streamline it, what are the potential savings? And then present a very clear case to policymakers of, here's a multi-billion-dollar let's say it's a $20 billion project that we think with these approval deadlines we could make into a $15 billion project or something, enabling us to do another $5 billion. Maybe that's the way to make the case, because otherwise, if you talk about these problems in the abstract, people say, I want my right to do this or that, and everything gets bogged down, and you get the NIMBY people from and often they have legitimate interests, but they are, in fact, probably subordinate interests to the greater good. But we need a way of talking about this issue that hasn't really come up, and maybe it's the planning and economic way rather than dealing in abstractions. Thank you all for coming. Thank you for the panel, and lunch is served. Thank you.